you all very much. It really is an honor to be with you. I'm Alison Packard. I'm an attorney in San Antonio, Texas, and I have some legal credentials that let me, understand this. But my best credential to speak to you today is that I am a mother of a daughter who's 26 years old, and she receives SSI. And so most of my really great experience in dealing with the Social Security Administration is my experience as a parent. I mean, that's where we learn the most. And but I'm happy to speak to you, and I especially love this group that is so focused on parents. And I'll just say at the outset, we have a lot to cover. If I don't get your questions answered, you are welcome to call me. I'll have my information at the end. Email me or call me, and I'm happy to talk to you individually. Okay, legal disclaimer is saying that this is a general presentation. I'm not giving you any particular legal advice. You talk to an attorney about your specific situation. That's the blah, blah, blah legal stuff. Okay, understanding Social Security benefits. If you feel like this picture, this woman in this picture, when you're dealing with the Social Security Administration, you are not alone. It is a very challenging organization to work with. And the reason is it's not the fault of the Social Security Administration. It is very complex. First of all, there is an entire Social Security language that we all need to master. And it's confusing. What's the difference between SSI and SSDI and RSDI and what's DAC? It all gets very confusing. There are literally thousands of laws and regulations that these Social Security workers need to learn and master. And not surprisingly, there is a high staff turnover. And you should just know that disability cases are really not as common as just general Social Security issues, such as retirement and dealing with Social Security cards. And so a lot of times the workers you're dealing with really don't have a lot of experience in disability issues. So let's just kind of go through a general overview. When we think about Social Security, most of us think about our retirement. We know that we are paying FICA taxes from our jobs, we're paying into the system, and one day we'll retire. The amount of our Social Security retirement is going to be based on how much we paid into the system. So we'll get a monthly payment based on our average earnings over our 35 highest paid years. If we are over age 65, we're going to have some Medicare health coverage in our retirement years also. Now, the age that we retire also affects the amount of benefit that we get. So first of all, the amount that we get is affected by how much we pay into the system. Second factor is what age are we going to draw that retirement benefit? If I retire at age 62, I'm going to get a lower amount than if I wait until my full retirement age, which for me is 67. If I can hold off on drawing my retirement until age 70, that's when I'm going to get the maximum amount of Social Security retirement. And that's the maximum for everyone. So there's no reason to hold off on drawing your Social Security benefits beyond age 70. You're not going to get any more money by waiting longer, but it will increase up to that age 70. If you don't know how much money you will get at all of those different ages, I encourage you to go create an account with the Social Security office. You just go to ssa.gov. It's very easy. You should create an account, and when you create that account, you'll be able to tell exactly what your benefits are if you retire at 62 or 67 or 70, etc. Okay, so what happens if I'm paying into this system, but then I die or I become disabled before I hit my retirement age? Part of paying into the Title II Social Security system, it means that I have insurance if that happens. So if I don't make it to my full retirement age because I have a disability and I can't wait, I can basically get my retirement early under Social Security disability insurance. So that's That's what SSDI stands for. It's that insurance component of the Title II benefit. There are also other people that are insured under my work record. So not only can I get my retirement early if I don't make it to my full retirement age or when I'm eligible, but if I have a spouse that needs to draw disability, that spouse can potentially draw off of my work record if they've drawn off their own work record first. Sometimes even an ex-spouse has that benefit. If I have minor children at the time that I'm drawing my benefit, those minor children also have insurance benefits coming to them. And then this third category is really important for those of us who are parents of adult disabled children. My work record, my insurance also covers any disabled adult child. Now, there are certain criteria to be considered a disabled adult child, but that is a really valuable benefit. A disabled adult child can get childhood disability benefits. That's the official title. And that is a benefit available for individuals who are disabled and are now over the age of 18 and not married. Their disability has to have started before the age of 22 and it's been continuous since the age of 22. And when I say continuous, we're talking about Social Security definition of disability. So we're going to get into that more. And that individual now has a parent who has died or retired and is drawing their own retirement benefits, or become disabled and drawing disability benefits. For that individual who qualifies as a disabled adult child, that CDB benefit, the child disability benefit, can be very substantial. It's up to 50% of the working parent's benefit, and it can be up to 75% if the parent has died. So let me give you an example of that. If I had Social Security retirement coming to me in the amount of $2,000, I get my full $2,000, and my daughter, who is a disabled adult child, can get half without lowering the amount that I get. So she gets $1,000. Now, there is a family maximum, but generally speaking, it's up to 50%. And then one day when I pass away, she will get up to 75% of my benefit. And then when her father passes away, she'll switch to his record because his record happens to be higher than mine. I took 10 years off to take care of my daughter. So, it's whichever parent has the higher work record, the child who qualifies for this benefit will switch to that parent's work record. Hope that makes sense. So again, I said to be eligible for this very valuable benefit, you have to show that the disability existed before the age of 22. What is the easiest way to prove that? You get into the Social Security system and qualify your child for SSI or SSDI before age 22. That's the safest way to prove it. It is possible to prove it otherwise, but it is very difficult, as you'll see from the definition of disability with the Social Security office. So we want to seriously consider applying for disability benefits for our children who might qualify for that lifetime childhood disability benefit. So how do you apply for disability? You can create an online account at socialsecurity.gov. You can also call the Social Security office. Back in the day, you could go to the Social Security office. Obviously, that's not an option right now. I don't know when that's going to return. So just disregard number 3 for the time being. Or number 4, you can use an attorney to help you file the application. I get asked all the time, do I need an attorney? And it really depends on your individual situation. There are many people who apply for disability, and it is very clear the disability is obvious. It's not going to be a problem getting the application approved. And so for a lot of people, an attorney really isn't necessary. And you should know, by the way, all attorneys charge the same. They will take 25% of the back pay. So if your case is approved quickly, there's very little back pay. If your case is one that has to be appealed and go all the way to the hearing, the back pay may be more substantial. But if you're in that situation with an appeal, you do want an attorney to help you. So again, you don't have to come up with money out of pocket. and it will be the same no matter which lawyer you use, 25% of the back pay. But for many people, you don't need an attorney. If you've got really great medical records and very evident disability, then you can very likely do it on your own. And whether or not it'll be easy for you, stay tuned and we'll go through and you can see how hard it would be for you to qualify. Okay, so we're trying to figure out how to qualify for SSDI or SSI, either of those. The first program, Social Security Disability Insurance, that again is the program that we have because we're paying FICA taxes, we're paying into the system. And if I become disabled, I'm going to get a monthly payment based on my work history and how much I've paid into the system. And then after a waiting period, I'm also going to qualify for Medicare. You have to be disabled for a couple of years before the Medicare kicks in. To qualify for SSDI, you have to be medically eligible and technically eligible. The medical determination is different for a child versus an adult. Disability for a child, the definition is very similar to what we deal with in the school systems. You're considered to be disabled as a young child if you have a medically determinable physical or mental impairment, and that impairment results in marked and severe functional limitations. And these are the kinds of limitations that are going to last. So it's not just a temporary situation. There are 6 different domains. We're not going to spend a lot of time here, so feel free to contact me if you want to talk about this in more detail. But basically, for a child, we're going to be looking at report cards. We're going to be looking at questionnaires that are filled out by parents and filled out by the school teachers. A lot of school records will be involved in this situation. And if your child qualifies as having marked limitations in 2 of these areas or very severe limitation in 1 of these areas, that's how they will be determined to be disabled. Once someone hits the age of 18, the determination of disability in the Social Security system changes. It is a new determination, and now it is based on the ability of the person to engage in substantial gainful activity. Substantial gainful activity, that has to do with being able to work. And we say substantial because obviously we want our children to be able to work, and it's great for them to work. I hear a lot of times people say my child can't work because she receives SSI. That's just not true. The question is, can they work a full-time job? There are many programs out there that allow our children to qualify for SSI or SSDI and still work part-time jobs, which is wonderful. But the substantial determination means if they're working more than 30 hours a week, if they're working a full-time job, that's a substantial amount. And if they can do that, you should celebrate, but you're not going to be eligible for SSI or SSDI. Gainful, there is a certain amount of dollars that are considered to be gainful amount of activity. So what we're saying here is someone who is not blind, if they are earning, this year in 2020, it's $1,260 a month. I went ahead and put next year's numbers on there. So if you are capable of earning more than $1,300 a month, that is a gainful amount of earnings. So if you're working a full-time job and earning over that amount, you are not disabled. So I want to make sure everyone understands that. Again, if you're able to earn money and work a good amount of hours and earn that amount of money, then you're not disabled in the Social Security definition of things, even though you may have diagnoses that seem to be disabling conditions. Okay, there is a 5-step medical evaluation. The first thing the Social Security office is going to look at is this person who's applied for disability, are they working? And we just covered that. If that person is working a substantial gainful amount, they are not disabled, and we don't move beyond question 1. If you're not working, then we move to question number 2. Is the medical condition severe? So disability payments are only for people with severe conditions. So if this is just a fleeting condition and not too serious, then you're not going to be considered to be disabled. Number 3, assuming you have a severe condition, we go to number 3. Does the medical condition meet or medically equal a listing? So in Social Security world, there's something called a blue book. And in that blue book, there are lots of medical listings. For example, one of my daughter's diagnosis is an intellectual disorder. And so we call it an intellectual and developmental disability in the blue book. Social Security calls it intellectual disorder. So I can look and see exactly what the Social Security is looking for as far as records and evidence of my daughter's disability. Does she have a sub-average IQ? Does she have deficits in adaptive functioning? Did that manifest before the age of 22? And if I look at that blue book, I can get all kinds of details of exactly what they're looking for. And so in her case, I know if I can give the Social Security Administration an IQ score report of 70 or below, that is going to help her get qualified for disability based on that record. And you can do this with whatever diagnosis your child has. You can look it up. If it's Down syndrome, you can see exactly what kind of evidence Social Security office is looking for. Okay? So you want to see if your child medically equals a listing. Now, for a lot of us, we're going to have to answer no to number 3. You know, maybe there is a disability, but it doesn't equal a listing. A perfect example would be autism. You know, autism, the listing really has to do with whether that person can engage in substantial gainful activity. And really, you can't always tell that from medical records because there's such a huge, you know, variety of abilities on the spectrum. So for a lot of people, we move to question number 4. Can the claimant do previous work? So this would be a situation, and this is the most common situation, where someone was working throughout their lifetime and became disabled. For them to get disability benefits, we have to make sure they can't do the work that they did in the past. For our children, a lot of them haven't been able to have a lot of jobs, so it might be an easy no. And then we focus on number 5. Can this person do other work? This is where it really is difficult to qualify medically for disability for a lot of people. It's not just, is this person working, but could they work? And so just saying I'm not going to work so I can qualify for disability, that doesn't cut it. You've got to have evidence that you are unable to engage in other work. And that's where, if you go all the way to a hearing, you might have some vocational experts provide testimony. That's where you could explain some attempts at jobs that failed. And that's why for a lot of people, we have to go all the way to a hearing, because sometimes the medical records are not clear to explain whether or not that person can work. And so we go all the way to a hearing to get into more detail. Any questions before we go on? That's sort of the medical determination.
There was one. Oh, yep, there's 2. Hold on just a second. The first one was, is CDB the same as DAC?
Yes, great question. Yes, it's the exact same thing. DAC is the more common title. It's actually not the official title, but everyone refers to it as DAC benefits, exact same thing. Great question.
This one is, I have a disabled adult son. I'm not 62 yet, and my full retirement age is 67. I understand that my son can get 50% or 75% when I'm no longer here. Of my Social Security benefits, will his benefit be based on when I draw my Social Security? Example, would his benefit be less if I draw at 62 than if I draw at 67 or 70?
Yes, that is a great question. My understanding is that if you draw at 62, it will be less than if you draw at your full retirement at 67. I'll be honest with you, I always thought that if I held off till 70, it would increase my daughter's age. My daughter's benefit amount. I recently learned that holding off till 70 is not going to increase that benefit beyond our full retirement age amount. Does that make sense? So yes, if you wait till your full retirement age, it is going to increase the amount that your child gets, but waiting until age 70 apparently does not. And I'm embarrassed to say I didn't know that until recently. So I'm learning with you, and it does change what we plan to do as parents. You know, I've been basing a lot of our decisions between my husband and I based on that benefit for our daughter. So that's a great question.
Great.
Anything else, Cinda?
Nope, that's it right now. You're doing great.
Okay, let's keep going. Okay, so that is, generally speaking, the medical determination. Now we're going to talk about the technical eligibility. So again, the medical eligibility is going to be the same whether we're looking at SSI or SSDI. The technical eligibility is going to be different. If you are going to be technically eligible for SSDI, you have to have work credits. The amount of work credits you need depends on the age that you're disabled. So, I'm in my 50s, I got to have almost 8 years worth of work. But my daughter, if she is applying for disability, if she was able to have a job for a couple of years, she may qualify on her own work record. But as we get older, we need a lot of work credits, and they need to be recent. So for a lot of our children, when we apply for disability, they get something in the mail that says you don't qualify for disability because you haven't worked long enough. This is the denial that comes to most of our children, and parents get panicked because they say, how could my daughter be denied? She's clearly disabled. Well, if you look at it, it might be that they're just being denied for SSDI because there's not enough work credits. So the system will determine whether or not that person had work credits. And again, we talked about that CDB or the DAC benefit. Even if your child does not have enough work credits of their own, the next evaluation will see, do they have a parent who is disabled or drawing their own retirement or deceased? And that might open up the SSDI door. But for those who don't have that, not enough work credits, maybe you stayed at home for many years like I did, maybe you're a teacher and you don't pay into the Social Security system, or maybe you're like my daughter and she just hasn't been able to earn those work credits. If you're in that situation and you're applying for disability, you're not going to qualify for SSDI. Instead, you get moved to the other system of SSI, Supplemental Security Income. This is the needs-based system. We call it means tested. It's basically the welfare system. It's the system for people who are poor and needy. And in this system, SSI, there is a set monthly payment maximum. So it's not based on how much we paid in because we haven't been paying in. There's no work credits to look at. So in 2020, the maximum SSI payment is $783. Next year, it's going to go up to $794 a month. In Texas, if you qualify for SSI, you also get automatic Medicaid with that. So that's a great thing about our state. It makes getting the Medicaid very easy. Once our children receive the SSI, they'll get the Medicaid also. Again, for SSI, just like SSDI, you have to be medically disabled, same system we've already talked about, same criteria, and then technically eligible. Now this time, instead of work credits, we're looking at finances. Are you poor? Remember, SSI is a needs-based program that provides basic food and shelter benefits. So if you have a lot of money in the bank or a very high income, you're not poor enough to qualify for SSI. And we see this a lot of times as someone gets older, they may have a very serious disabling condition, but if they have a big bank account, lots of assets, they just won't qualify for SSI. So if they don't have the work credits, they just don't get disability. So let's talk about the income that Social Security Administration is going to look at. They're going to look to see what is the amount of earned income coming in. What about unearned income? In-kind support and maintenance, and deemed income. So earned income, let me see if I have a slide. Okay, yep, I've got some slides. Let's go through it. Deemed income is what I'm starting with. So deemed income is where a spouse's income counts for the other spouse, or a parent's income counts for a child under the age of 18. So what that means is if you have a young child, no matter how disabling their condition is, if you go and apply for SSI, they likely will not qualify because your income as a parent and your assets count for that child. We have a legal duty to support our children until they turn 18, so our income and assets count for them. Once our kids hit the age of 18, however, now our income as a parent and our assets, they're irrelevant, okay? So it's, for a lot of people, they qualify for SSI after they turn 18. ISM income, it's a kind of a funny type of income, but it's an important one to understand for parents like us. ISM is food and shelter that somebody provides for free. It's called in-kind support maintenance. So the general rule is if you are receiving SSI, but you're living in someone else's house for free, your SSI is going to be reduced by 1/3 of the maximum rate. So in 2020, instead of getting $783, you get $522 because your benefit was reduced by 1/3. That's called ISM income. And it happens when kids live in the house with their parents for free, or also when a special needs trust is paying for the apartment. Anytime they're getting free food and shelter, you're going to be looking at ISM income. Okay, unearned income, just what you would imagine. It's income that's coming in that is not being earned from a job. A great example of this would be a gift. If someone gives you a gift, that's unearned income. Or if you have a personal injury settlement, say you have a car accident and you get paid a settlement, that would be unearned income. Same thing with child support. We'll talk about that just briefly. Child support, once in Texas, we do have lifetime child support available, but once your child hits the age of 18, even though the payments going to mom or going to dad, the income counts for the individual with disabilities, okay? And we count all that income dollar for dollar, except we give $20 that we don't count. It's called a $20 disregard. Military survivor benefits is another one. We'll talk about that. So let me give you a quick example. If my daughter gets a $500 gift from her grandma, she can disregard the first $20, but she has to report that gift. And then other than that $20, her SSI payment is going to be reduced by the rest of the money. So you take the $20 off the $500, her next payment after I report it, her benefit is going to be reduced by the $480. Hope that made sense. So you do have to report unearned income and it will reduce benefits. Earned income is a little different. We want to encourage people who receive SSI to work. And so it's always better to work if you can, and you always end up with more money if you're working. So for earned income, Social Security Administration will not count the first $65. So you get the $20 if you haven't already used it, that $20 disregard. And then if it's earned income, you get an extra $65 that doesn't count. After that first 85 bucks, then whatever you earn is going to reduce your benefit by 50% of the earnings. I don't know if that made sense. It basically, Social Security will reduce $1 for every $2 that are earned over $65. So let's give an example. So if my daughter earns $485 in a month, if she didn't already use up that $20 disregard, we're not going to count that. And because it's earned wages, she doesn't count the next 65. So now she's down to $400. You'll see I made the math easy for me. So we deduct that $400, we deduct half of that from her next payment. So instead of getting $794 on her next payment, she's going to have it reduced by $200 and she'll get $594. I hope that made sense. But you'll see she ends up with a lot more money because even though her SSI is reduced, she gets that $485 that she's earned. So she's earned, she has more than $1,000 coming in that month. And so I think it's great to let our children work whenever they can. You just need to understand how these systems work and how to report and how to make sure that they're still qualifying for their benefits. Okay, there are some exclusions. If someone is under the age of 22 and regularly attending school, then they get some exclusions and their SSI benefit is not reduced at all. There are also other programs that will allow you to keep the full amount of SSI. We don't have time to get into all of those, but you should just know those are out there. All right, so Ticket to Work, that's one we're very familiar with, and that is a program that lets you keep some of your earnings also. All right, we're going to move on. Resources also have to be measured. So remember, we're trying to see, is someone eligible for SSI and how much will they get? And we know they've got to qualify medically, but once they qualify medically, we have to see if they're qualifying financially. So we're evaluating all those types of income that we discussed to see if they're eligible and see how much they will get. And then the other thing we have to evaluate are assets. In Social Security world, we call an asset a resource, and a resource is anything that can be converted to cash unless it's excluded by law. So what I mean by that is, if you have a 529 plan and you have the right to go in and cash it out, that is an asset for you. So think about that with your kids. If I bought a whole life insurance policy and my daughter had the ability to cash it out, that would be an asset for her. So we want to think about, any kind of trust account. If it's not a special needs trust, we're going to get into that just briefly, but a regular trust account, if there's an asset that can be converted to cash by the person with disabilities, that is a resource. And it doesn't matter if there's a big tax penalty and you're going to have to pay a bunch of money for cashing it out. If you have the ability to cash it out, it's a resource. And total resources have to be below $2,000 on the first day of every single month to qualify for SSI. And just a reminder, spouses' resources count and parents' resources count for minor children. We talked about that. So we have deemed income. We also have deemed resources. Okay. So there are exclusions, things we don't count. You get to keep up to $2,000 and still qualify. You can have a home of any value and qualify. You can have a car. You can have a washer and dryer and bedroom furniture and all of that. That's not going to, cause problems with your benefit. You can have a burial policy. And I want to focus on these last two at the bottom. You can also have a special needs trust and an ABLE account. A special needs trust, any amount of money in that special needs trust is not going to count towards that $2,000. It's just an exclusion. It's not a regular trust, it's a special needs trust. ABLE account is similar, but there is a cap on it. You can't have any amount, but you can have up to $100,000 in an ABLE account and still qualify for SSI. Now, I submit nobody wants $100,000 in an ABLE account because there's a Medicaid payback on it. And that's a whole nother presentation where we get into those details. But let me just hit some really quick highlights to make sure you understand what I'm saying. When I say a special needs trust is exempt, we are talking about a very particular kind of trust that's only available for someone who's disabled, and the beneficiary control is very restricted. There has to be some specific language in that trust to make it qualify as a special needs trust. So if you're in the situation where you're getting a special needs trust, just don't do something online. Don't go to a lawyer who doesn't do this regularly. It's a very particular kind of trust, okay? And I just want to also touch on this. There's two kinds of special needs trusts you should know about. A first-party special needs trust, that is a trust that's funded with assets that belong to the person with disabilities. A third-party special needs trust is funded by other people. And if you have a first-party special needs trust, it must have a Medicaid payback included. So what that means is, if my daughter Angela gets a big personal injury settlement and she moves all that money to a first-party special needs trust, she keeps her benefits. That's not a problem. But one day when she dies, Medicaid gets paid back out of the remaining funds in that trust. And I'm sorry, we're going to go quickly because we're really focused on Social Security today, but you can feel free to ask me more details about that later. So with Social Security benefits, they are affected a lot of times by these personal injury settlements, inheritances that are received, maybe child support, military survivor benefits. There are ways to fix that problem and still qualify for SSI. So let me just talk about a couple of them. Child support, as I mentioned, lifetime child support is available in Texas. So if your child receives lifetime child support, you can have that child support irrevocably assigned to a first-party special needs trust. You can't just move the money yourself into the trust account. You have to have it assigned by court order. So you're going to have to involve the court to get it done correctly. But if you do that, then the child support will not reduce your child's SSI. Otherwise, the child support is going to count as unearned income. And if you remember from earlier, unearned income is going to reduce the SSI dollar for dollar. And so for a lot of people, that makes the child ineligible. So again, if you have lifetime child support, you can get a court order assigning it to a first party special needs trust, and then it won't reduce the SSI. Okay. Same thing with military survivor benefits. We weren't able to do this until just a few years ago, but at the end of 2014, the Disabled Military Child Protection Act passed, and now military SBP can also be assigned to a special needs trust. It has to be, again, that first party special needs trust with the Medicaid payback, but we're happy that we can now do this, and military families aren't asked to choose between military SBP or SSI and other Medicaid programs. Okay, so this slide was just to say, you know, we want to watch these kinds of things. If grandma wants to leave an inheritance, she can leave it to a special needs trust. But remember, if she leaves it outright to the person with disabilities, once they own that money, once grandma's died and left it to my daughter, Angela Packard, it's her money, and the only kind of trust she can use is the first party trust. We don't like that Medicaid payback, so you'll want to talk to grandma and make sure she leaves it to a third party trust. And that one has no Medicaid payback. And I'm sorry to whip through this, but I do want to get on to, you know, other details about Social Security. But you should just know there's a lot of benefits to special needs trust for money management. And if you have a child who's on SSI and Medicaid waiver programs, you do want to learn more about that. Okay, the ABLE account, just briefly. ABLE account, similar to a special needs trust. You can have money in an ABLE account and it will not cause problems with benefits as long as it's less than $100,000 for SSI. You're still eligible for SSI if you have up to $100,000 in an ABLE account. An ABLE account is a tax advantaged online account, so you don't go to the bank and say, I need an ABLE account. You manage it online, and there are limits as to how much can be contributed every year. But again, without getting into a lot of details, this ABLE account has a Medicaid payback on it. So you don't want to use an ABLE account to grow a nice, huge savings account for your child, because if your child dies, Medicaid's going to claim what's there. So a third party trust is much better. But the reason I want to spend a little more time on ABLE accounts is that ABLE accounts can actually be used to eliminate that ISM charge. Remember how we said if somebody's living for free in their parents' home, their SSI is going to be reduced by 1/3. Or if a trust is paying for it, it's going to be reduced by 1/3. An ABLE account actually gives us a way to get rid of that penalty. The reason is, again, this is a quick review. In-kind support and maintenance is a type of income when you're getting free food and shelter and you're receiving SSI. Okay, again, general rule, it's going to reduce your benefits by 1/3 of the maximum rate. So in 2020, you're going to get $522 instead of $783. We don't need to get, there is a little bit of a difference. Oh, that's the 2021 rates. There's a little bit of a difference if a trust is paying versus living in your parents' house. Okay, the way you avoid that penalty, you tell Social Security, I don't want to pay that penalty. And you can get rid of that penalty by having the person who receives SSI pay their fair share of household expenses. That's how you get them to get rid of the penalty. Now, what are the household expenses? There's 10 items that Social Security counts as the expenses they're looking at. So you'll notice it's not the cable bill, it's not the cell phone, it's not what you might think are the expenses of the household, it's these 10 items. And so what you do is you figure out what is our household expenses of these 10 items, and then figure out how many people are living in the house. In my case, it's my husband and I and my daughter. So I add all these things up and divide it by 3 because there's 3 of us. That is my daughter's fair share of household expenses. So I'll give you an example. If I had rent, then these, are some numbers we can make it easy. $850 in rent, and say the electricity and gas and water and garbage all added up to $1,500 a month. If that was our total, divide it by 3, her fair share is 1/3 of that, which is $500. And what I would do is I would turn in all my bills to Social Security Administration. I'd say, here's a copy of my lease agreement, here's our electricity bill, here's our water bill, and her share is $500, and she is going to pay me every month that $500. So that works easily for a lot of people if you just turn your bills in. Now, what if the person receiving SSI doesn't get enough money to pay their fair share? And this is very common. So say instead of an $850 rent payment, it's a $2,000 mortgage payment. Well, then it might be hard to have enough money to pay the fair share. If the SSI individual doesn't get enough money to pay fair share, there's different things you can do. You could have a lease agreement. You could show that you're in a public assistant household. But again, we're focused on this ABLE account option. ABLE accounts, once money is put into an ABLE account, the money is used for qualified disability expenses. And this includes, according to the IRS, housing. So housing is a qualified disability expense. Anyone can donate money to an ABLE account. My daughter with disabilities can put her own money in there. I can donate money in there. Grandma can add money to the ABLE account. No matter who puts it in there, once it's in there, it belongs to the beneficiary. So if I donate money to the ABLE account, it's now Angela's money, and she can use her ABLE account to pay her fair share because it's her money, remember. So say her fair share instead of $500 is $900. She can use her SSI payments to pay part of her fair share, and she can use her ABLE account to pay what's left, and then she doesn't have an ISM reduction. So I know I'm going kind of quickly through this, but basically you need to figure out the fair share of household expenses, and maybe you just need to turn in the bills and then make sure that Social Security knows that, you know, the individual on SSI is going to start paying their fair share. If they don't get enough money, you may need to use this ABLE account option. And then it's not enough to just say you're going to do it every single month. You need to actually transfer money from the ABLE account to pay you. What I do is I just transfer it online. Every month I say, this is Angela's ABLE account payment for her fair share. And so talk to me, feel free to call me, or we can talk more about that at the end if anyone has more questions. Okay, I'm looking at the time, excuse me. Okay, let me hit just a couple of things about appeals. Or Cindy, do we have any questions I need to stop for before we get into this?
Just a couple. One. So there seems to be a little confusion on a special needs trust. Somebody heard you say that if a special needs trust can be converted into cash, it counts. So I think there was something that was not clear. And I think it was, you were talking about if somebody gives them money, or if, I don't remember exactly what it was.
All right, I apologize. I don't know exactly what I said, but let me.
I don't either.
Yeah, let me just briefly, and special needs trust, that could be a whole nother hour or two presentation. So I'm sorry to kind of hit this quickly. A special needs trust, if it's properly drafted and properly administered, all of the money in that trust does not count. You could have $1 million in a special needs trust and it does not count. So as long as the trust is drafted correctly and administered properly, meaning the trust is for the individual with disabilities. So if I take my daughter's special needs trust and pay for the whole family to go to Disney World, she's in trouble. She's going to lose her benefits because I'm not using it just for my daughter. So you have to administer it properly. Now, if it's not a special needs trust, then the money counts. Okay, so I hope that was a little more clear.
Yes.
So
yes.
And ABLE account, same thing, will not count. You can have up to 100,000 and still be eligible for SSI. You can have even more in an ABLE account if you're only trying to protect a Medicaid program. But again, I don't know why you want a huge ABLE account because it's got a Medicaid payback on it. So I hope that was a little more clear.
I think it was.
Contact me if I'm still confusing you.
No. Minors living in the home don't count the fair share division, correct?
No, they do count. You report how many people are in the home, and if you have minor children, that's still a body in the home, and that's good because it lets the fair share be a lower amount. So yes, you do count the children. And you need to always update Social Security. We're going to get into this a little bit. When someone moves out and goes to college, you need to tell Social Security, now we have one less person in our house. And it might change the fair share calculation. It will change it.
Okay. And then I'm going to ask one more and then let you keep going because I know you've got so much to cover. Are you okay if we share this presentation with everybody afterwards?
Sure.
Okay. We'll put it up on our website at Texas Parent to Parent. Give us a couple days and we'll get it up there. So you'll have access to your slides.
Okay, great. All right, let's keep going. A lot of times when you're, oh yes, go ahead.
Can you take another drink and give Zeke a 30-second break?
Sure. Okay, thanks, Zeke. I'm sorry. Okay. All right. Zeke, I hope I'm not going too fast. Nobody's
okay.
told me to slow down.
He's good now. He just
Okay.
needed a breather. So
Okay.
carry on.
Okay. When we deal with the Social Security Administration, we all learn that mistakes are made. It's frustrating and it's common. And I will tell you, I do this professionally and I still sometimes want to cry or pull my hair out when I'm dealing with things with my daughter. So if you feel like that, you're not alone. And again, we kind of talked about that at the beginning. There's just a lot of confusing issues to work through. But if you think a mistake has been made, you can appeal, and don't be afraid to appeal. If you are appealing a medical denial, so if Social Security Administration has told you your child is not disabled, and I'm sorry to just assume we're talking about our children, it's just easier for me to talk that way since we're a parent group, but we're going to assume that we're talking about our kids. So if you get a letter and your child is found not to be medically disabled, you can appeal that. I would be careful about appealing that type of issue by yourself. That type of issue, you probably want an attorney to help you because there's a lot of ways to mess it up. But you can appeal it by yourself if you feel confident in doing that. But there's going to be a lot of other things that might come up that you can handle on your own. You can appeal any mistake. So if you get told your child has to have that ISM penalty and you've turned in all the documentation and you know that they're paying their fair share, you can appeal it and say, no, that's not right. I want to appeal it. When you file an appeal, you can ask for either a case review, an informal conference, or a formal conference. This is a great tip, if I do say so myself. If you're talking about money, do not check number one, case review. Social Security, if it's a medical issue, that's your only option. If they're saying that you're medically don't qualify, you've got to do case review. But if you're dealing with money, then pick informal conference because that is going to give you someone to talk to. The case review just means the Social Security office is going to look at it again, and I will tell you, 90% of the time they're going to say, yep, we were right the first time. So, ask for an informal conference. And again, our days of COVID are a little bit crazy, but assuming we get through this COVID pandemic, when you have an informal conference, you can go to the Social Security office, they'll have someone there. And I've been able to work out all kinds of issues for myself, my daughter, my clients, once you get face-to-face with someone and you can kind of work through it together. So I would always check informal conference or formal conference if you want that. But it's easy to have an informal conference without a lawyer even being involved. If you're going to select an informal conference, you do have to do it within 60 days of the notice. So you only have a couple months to appeal. And if you jump right on it and get your appeal in within 10 days, the benefits will continue. So that's an important point. If you get a letter in the mail that says your benefits are going to stop, you need to immediately appeal. Get that in within 10 days. That way they have to keep the benefits going until it's worked out. Okay. Informal conferences are very rare. Most people just ask. Most of the appeals are for medical issues, so it's almost always a case review that the Social Security workers are looking at. So if you are going to ask for an informal conference, I would highlight it or put a big circle around it. Emphasize that you want to get in and talk to somebody. Okay. If you can't work things out at that first step, then you might have to ask for a hearing. And this is very common in the world of Social Security. So if your child is medically denied and you ask for a case review, very likely they're going to send you a new letter and say, still denied. You know, it's unusual. I've seen it, but it's unusual that gets reversed. But if you go all the way to a hearing, then you're going to get in front of a hearing officer and you can explain to the judge why your child is disabled. You tell the stories, you know, my child tried to work and we had Texas Workforce Commission helping us and this is what happened and they lost this job and then we did this, and you can get in and give more details. So a lot of people do not win their disability case until they go to the hearing level. It just means if you need a hearing, it means that the medical records were not clear on their own. And, you know, again, I mentioned autism. That's the perfect example. A lot of times a diagnosis of autism is not going to tell the judge anything. Unless your medical records are very detailed, the judge is just going to know, well, autism is such a spectrum. I can't tell if this person could work, so I'm going to deny the case. So don't be afraid to appeal and go to a hearing. Again, my recommendation is have a law firm help you if you're doing a medical appeal. If it's a financial issue, you might be able to handle it on your own. If you're appealing a special needs trust, get an attorney to help you. Okay, you should also know that this appeal is a slow process, okay? So for a lot of people to get their final determination of disability, it might take 1.5 years. And I'm sorry to break that to you. You know, San Antonio, our area is a little faster. I can't remember, I guess I didn't hide that slide. You can see sort of where your area hits, but it's going to take a long time to get through the appeals process. You should just understand that. Okay. Another thing that often happens in the world of Social Security is we get a notice of overpayment. This is extremely common, and it's a lot of times not something to panic over, and sometimes you should panic. But for those of us who have kids that are working, this is very common because they have to report their earnings. A lot of times the calculation is done, then it's done incorrectly. And, you know, the Social Security office uses something called retrospective accounting. I think that's the terminology. Basically, you turn in the information to them about some earnings you have, and then they calculate it and it affects your benefit the next month. Does that make sense? So you're reporting earnings from last month, but it doesn't affect the check until the next month. So there's sort of like a 2-month delay in correcting the amount of benefits. So that leads to a lot of overpayments. So sometimes they're just small amounts being corrected for earnings, but other times there could be a more serious issue. A lot of times overpayments happen because somebody receiving SSI does not report a change. So we already mentioned, you know, if your child goes off to college, you need to report that and say, we now have one less person in the house, because maybe there should be an ISM penalty happening again. Maybe your child is no longer paying their fair share. And even though you think it's right at the time, if you didn't report the change, then you'll have to pay that money back. Does that make sense? So if I calculated a certain ISM amount and then my son went off to college, that ISM amount I calculated is now wrong because the fair share would be different, which means if my daughter was getting the full amount of SSI, once Social Security figured this out, there's going to be an overpayment. She's going to have to pay back those months where she received too much. So it happens. The most terrifying situations are when it's something like an inheritance that was received. And, you know, say parents die and they leave money to a child on SSI, or grandma leaves something and nobody reports it for 3 years. This is a little scary, but, you know, it doesn't matter if 5 years down the road, we realize we should have reported it. You're going to get a bill for all of those months that SSI was received because you were ineligible. Common situation happens. Maybe there is a whole life insurance policy that made the person receiving SSI actually ineligible, but it wasn't discovered. Unfortunately, once it's discovered, the Social Security office is going to go back and see, well, that means that person was ineligible for benefits all those months, so you have to pay us back. Okay, so it is something to take seriously, because I've seen overpayment bills for more than $100,000. Now that's not common, but it can happen. So the biggest advice I would give you is make sure you are reporting any change, reporting any money coming in. Don't think, well, I'm going to get away with it. They'll never know. You always report if money's received by someone on SSI, okay? If you do have an overpayment, you have a few options. You can appeal it, and those are those same steps we talked about earlier. So, you could ask for an informal conference and go in and sit down with someone and explain what happened. You could go all the way to a hearing and talk to a judge about it. You can also ask for a waiver, and you can ask for a payment plan. You can ask for a compromise, or you could file for bankruptcy if it was high enough. You could say, well, we're never paying that back, so you file for bankruptcy and it wipes it out. The waiver is difficult to get. You should just know that. To be eligible for a waiver, then you have to provide evidence that you cannot afford to repay this and the overpayment was not your fault. So that number 2 is pretty tough to prove. So you have to show, look, I reported this. Here's my certified letter. You just didn't get it, but I did report it to you and I can't afford it. I really need this money. Then maybe I can get a waiver under those situations. More typical is going to be a payment plan. If you're receiving SSI, you have an overpayment, the Social Security Administration is going to offer automatically to withhold 10% of the check. So instead of $794, if you have a really large overpayment, they'll take 10% and they'll reduce the check by that $79, okay? That's going to be their offer if you're on SSI. You can negotiate and say, I can't even afford $79. I need just $30 a month or $50 a month, and come up with a payment plan. If the benefit being received is SSDI, not SSI, then they can withhold your entire check. And so that's important to understand. So if you're in that situation, it's not limited to the 10%. Remember, SSI recipients are considered poor and needy. So there's some protection to make sure you have some income to keep you, able to have basic food and shelter. But SSDI is not for someone who's poor and needy, so they can keep the whole check. So you need to talk to the Social Security Administration and say, we have a big overpayment, but I really can't lose my check, and you can work out a payment plan. You can also sometimes have a compromise and negotiate the amount that is paid back. That's more the case where there's some kind of questionable legal issue. But you should just know that you don't have to go write out a check. If you get a notice in the mail saying you have an overpayment of $10,000, that notice is bound to tell you, please pay it immediately or within 60 days. You don't have to go pay it right back. You just need to contact the Social Security Administration and work out a plan to pay it back over time. Strategies to avoid overpayments. I already mentioned you should report your changes to the Social Security Administration, especially when it has to do with money. Always report changes by the 10th day of the month following the change. So if I get $20,000 this month from a car accident, I need to report it by the 10th day of next month. Okay, and as long as you're always reporting, it's going to get your overpayments under control. And then the other thing I would say is just watch out for letters from the Social Security office. We get a lot of them, and my heart kind of drops when I get them in the mail. But it's important to open those letters. I cannot tell you how many people come see me and they just threw that letter in a corner. They didn't understand it. They didn't deal with it. If you're confused what the letter means, get help interpreting it. Call the Social Security office, call an attorney, call me if you need help. But make sure you understand what that letter is telling you, because you cannot just ignore it, or you could have a problem that escalates. And I think that's a good stopping point. I wanted to keep it to about an hour. I'm happy to entertain questions, but let me just say here, I'm serious about taking down my contact information. You are welcome to email me or call me. I usually do charge a consultation fee, but for parents, for groups like this, just tell my secretary that you're with Texas Parent to Parent and that the consultation fee is waived. If you just want to talk by Zoom about your specific situation, I'm happy to talk through that with you. I will give you the disclaimer. I don't personally file the Social Security applications. I have lots of lawyers at my law firm that does it. I'm more the special needs trusts and guardianships and those issues, but I certainly am happy to talk through your issues with you, and I can get you in touch with someone if you need legal representation, or you can find another firm. You know, there's lots of attorneys that do Social Security work. So if you need help finding someone, you know, just let Cinda know or me know, and we'll get you to somebody. Okay.
Thank you so much. That was so much information, and great information. So let's just jump into questions. And if you put a question in and I've missed it, get back in the chat. Can you talk about caregiver benefits? I was married 10 years. My child's dad is 67, but has not yet filed.
Okay, I'm not sure I understand that question. Caregiver benefits meaning through a Medicaid program or through the Social Security Administration?
So isn't there something under Social Security that if you're divorced and you're the caregiver, you could potentially be entitled to benefits off of your ex's
Yes, okay.
records? I think that's what they might be talking about.
Okay, honestly, I'm going to have to look that one up.
Okay.
I'm not as familiar with that. There are some benefits, and there's also a program, and maybe this is what you're getting at, where you can get your full retirement amount of Social Security before your full retirement age if you are a full-time caregiver. So that might also be what you're referring to. And so there are some specific things you have to show the Social Security office, that you know that you're needed at home to provide full-time care, and because of that you need to draw your retirement early, and as long as you get all that information to them, you can get bumped up to your full retirement amount. So yes.
Excellent. Okay. A disabled adult child can only receive Social Security when his parents start drawing Social Security, correct? So if the parents wait until 67, the disabled child also has to wait. Correct?
Yes, that's true. If the disabled adult child does not have their own work record, remember, they don't need as much in the way of work credits, but say they don't have any work credits or not enough, then they're not going to draw SSDI off of a parent's work record until that parent is drawing the benefit, or if the parent dies. So the child draws it when the parent is getting their own Social Security retirement or Social Security disability, or the parent is deceased and it comes by way of that survivor type benefit.
Excellent. Does child support over 18 count as in-kind support or unearned income?
It counts as unearned income. It's dollar for dollar reduction. It's not in-kind support maintenance.
So if you have child support and say we run into it a lot where if somebody has child support and it still keeps them eligible for SSI, SSI starts taking the child support off of the lower amount, the 522.
Yes.
Because and is it because they consider that that's already helping with the expenses? So in essence, it's kind of in-kind support, or no?
Yeah, I understand it is. Your argument would be, well, it is obviously in-kind support. That's what the support is for, is to pay the expenses. But there's specific regulations in the Social Security POMS, we call them, the Program Operation Manual system, and they specifically tell the Social Security workers if there's child support over the age of 18, it is unearned income and will reduce the benefit dollar for dollar. So this is the perfect example of how an overpayment could happen. If you have not reported that child support, then that amount of child support received should be reducing the benefit dollar for dollar if it hasn't been court ordered to be paid to a special needs trust. And so if you haven't reported it, unfortunately, when it gets discovered, you're probably going to have a big overpayment for all those months when SSI was still being paid. So I hope that's clear. So again, if you have child support, you can do an agreed order. I have a lot of parents. I'm not a family law attorney. I don't do divorces, but I will sometimes help someone as long as everyone agrees, which occasionally happens. They can just do an agreed order that says, we want our child support now to go to a special needs trust. and then we do an agreed order, submit it to the same court, the judge signs off on it, and now the money's deposited directly into the special needs trust account. We turn in that agreed court order to the Social Security office, as well as a copy of the trust itself. Remember, it has to be a first party trust with the Medicaid payback. They review it, and then there's no reduction in benefits. If you don't happen to have the situation where you and your ex are agreeable, then you probably need to go find a family law attorney. Sometimes the Attorney General's office will help with this situation, but it's a little bit complicated with them.
Fair enough. Okay, great. If someone on SSI receives an inheritance, they report it right away and then spends all the money in a month, does he just lose benefits for that month?
Great question. And yes, you're spot on. If you got $10,000 and then you went out and bought a car, you need to report the income because you were ineligible in that month because of income. But remember, income is measured any time during the month. Resources are measured on the first day of every month. So if that money was spent before the first day of the next month, then you're eligible again. So you just lose that 1 month. But you've got to be able to show Social Security how it was spent. So you need a receipt. You need to show them that it was spent on the person. You can't just give that money away. But yes, you got it. That's exactly right. That's how you can do it.
Excellent. Yes, we will be posting the slides on our website at txp2p.org. If fair share is very high because the mortgage is high and they can't pay their fair share, can there be a rent agreement instead?
Yes, you can do a rent agreement that works, but the rent agreement, it needs to be fair market rent. And so you can't just say, my child is living in this wonderful, 8,000 square foot home and is going to pay me $100 a month. It's got to be fair share market rent, but it could be that they're just using part of the house. The only reason I'm not crazy about that option is I think it's income for the parent. And I don't want to report income to, have more taxes. So my preference is the ABLE account. And if you didn't follow all that, feel free to call me and I can talk you through that a little bit more. But generally speaking, now an ABLE account is only available for someone who's disabled before the age of 26. So it's not going to work for everyone. But if your child was disabled before the age of 26, my general preference is to use the ABLE account option rather than a lease agreement. But they both do work.
Okay. Is there somebody at your law firm that can help with caregiver benefits for SSDI?
If we're talking about applying so you get it early, yes, contact me and I can get you in touch with our Social Security department. If that's, I think that's what you're referring to. So
yes.
just let me get you in touch with somebody in that department.
So if a parent cannot work and receives SSI, can it switch to SSDI when the parent takes their Social Security at 67?
Yes, absolutely. And by the way, this is the common situation for most of us. Our kids, typically speaking, I know we're not all typical, but, for the majority of us, when our children go to apply for Social Security disability, their parents are both working. And so a lot of times they start out on SSI, and then as the parents age and then we retire, then our children switch from SSI to SSDI. And ideally now they're under that childhood disability benefits program. So when that happens, they're no longer under a needs-based program. They've moved from SSI to SSDI, and SSDI doesn't have all those restrictions. So that's going to make life much better with the Social Security Administration. You don't have to report every little bit of income because now they're not under that type of program. However, for most of our kids, we want them to keep the Medicaid. Remember, SSI comes with Medicaid, SSDI comes with Medicare, but for most of our children, we want them to be Medicaid eligible so they can have access to Medicaid waiver programs such as HCS and CLAS and those types of programs. And so even though now we're not under that SSI system, we still have to watch, how much income we have and our resources because we want to make sure our kids stay Medicaid eligible. But I will tell you, I think it's easier to work with the Medicaid office than the Social Security Administration. So
that's fair. Okay, Rosalba is going to ask you a couple of questions that she has received.
Okay.
Okay. The first one is, In case that one of the parents doesn't have social security number, but they pay taxes because he's still working, does he qualify, the child qualifies for SSDI?
So it's not a tax issue. It really is a social security issue. So to figure out if there's any coverage there, you could go to ssa.gov and try to create an account and see if there's coverage. But paying taxes is not going to be enough. It has to be paying into the system.
I think another way of understanding this question is somebody who doesn't have a social security number can apply for retirement?
That's a good question. For SSI, if it's SSI, you have to be a US citizen, but you don't have to be a US citizen to get retirement. So you very well may be eligible, and it may open the doors to SSDI. But that would be, I'd have to do a little research to see if you would qualify. But I do know for sure there are people that receive SSDI that live out of the United States of America, and their children qualify for these payments. But if it's SSI, it is more, it doesn't work that way.
Thank you. Another question is the help, the financial help that the city gave for COVID, do they need to report that as an income?
Yeah, that's a great question. It will not count as income. So if you didn't report it, I don't think that's going to be a big deal, because it definitely does not come. The regulations does not count, excuse me. Regulations are clear. So if you reported it, that's great. If you didn't report it, you want to, that's fine, but it's not considered income that reduces the benefits. So that was a great blessing for all of us who have kids who got that $1,200 payment. It didn't reduce any benefits.
Yep. Is that it?
Yes, even if our kids have a disability, do they need to apply to, do they need to work in order to apply for SSDI?
Okay, so anyone can apply for disability. You can apply if you've been working or if you've never worked. There are many people who are going to qualify because their disabilities are so severe, they obviously could not work a job. You can apply after you've worked a few years, and then now you can no longer work. So there's no set time that you have to apply, and you can apply as many times as you want. What I did mention earlier is for our children who are turning 18, for some of them, it is difficult to qualify for disability if we don't know if they're able to work or not, because they haven't tried. So sometimes the Social Security Administration has the attitude of, we can't qualify you as being disabled because you've never tried and failed. We need to see you make an attempt at working. So, and by the way, let me just say, if your child can work full time and earn money, you should celebrate. That is a much better option than being eligible for SSI or even childhood disability benefits. So that's a great thing if you can work. But sometimes our kids try and they have support in place, but as that support goes away, it becomes difficult and they can't keep a job. Those are the kinds of stories that you need to explain to the hearing officer, and it will help get qualified for disability.
Thank you.
Great question.
Can you explain or re-explain about which parent the SSDI has to come from? If the father reaches 67 first, does he go with him? And then what happens later? So if they go with the dad and mom retires and her retirement benefit is higher, what happens?
Yeah, so it's going to switch to whichever parent has the greater work earning record. So as I mentioned earlier, I didn't work for about 10 years. So when I retire, it's going to be a lot lower than my husband's. So, and I think I'm retiring first. So my daughter will go on my work record. And then as soon as my husband retires, she'll just bounce right over to his because it's a higher amount. It should happen automatically, but I think it's a good idea to write something down for, put it in your will or next, paperwork that go with your wills or your trust. Just explain that somebody needs to go talk to the Social Security office, especially when someone dies. We want to make sure that that larger payment kicks in. But it's supposed to happen automatically. It just always, a lot of times it doesn't work that way. And let me say one other thing on that. When someone switches from SSI to SSDI, they are going to lose Medicaid because the type of Medicaid program they're typically on is SSI linked Medicaid. They can get Medicaid back. Again, that is also supposed to happen automatically. There's supposed to be a flag that goes up that this person is a disabled adult child and they lost their Medicaid only because they switched to SSDI. It doesn't always work the way it should. So you want to make sure you get into the Medicaid office and say, no, we also need Medicaid in addition to the Medicare. So you can get it back if it didn't happen automatically. It's just under a different type of Medicaid program, disabled adult child Medicaid.
Good one. What happens if you don't have a mortgage? Can you charge your rent to your disabled child?
Sure, you can still charge rent, but you could also just say our house is owned, so the fair share is much less. If you don't owe anything on a mortgage, then you have a smaller fair share. There's nothing wrong with that. You just say we own our house, so here's our electricity bill, here's our water bill, our garbage bill, here's our property taxes, and it's a smaller amount. It might make it a lot easier to qualify.
Can you put a $10,000 inheritance in an ABLE account instead of spending it?
Yes, as long as the inheritance went to somebody who was disabled before the age of 26, that's a great use of an ABLE account. You could also put it in a first-party special needs trust, but a first-party special needs trust, you're going to have to hire an attorney to do it, and so you're going to use a lot of the money just getting the trust set up. So if it's under 15,000, it's 15,000 for the whole year from everybody all together. But if you haven't already used that 15,000, that's a great time to use it. Put it in the ABLE account.
How can you tell whether it's actually Social Security who is contacting you or whether it's a scam?
So that's a really good question because this is a big problem. I know that the Social Security office will never call and ask for any kind of Social Security number or anything like that over the phone. And I believe there are very limited times they will call you. So if someone says they're calling from the Social Security office and you haven't gotten a letter, I'd be suspicious. There are reviews that happen, and obviously they're happening by the phone, over the phone, but that would be a scheduled appointment. So for sure, don't give out a Social Security number. And then I would just hang up and call the Social Security office back and say, do I have an appointment scheduled? Someone contacted me, because this is a real problem. There's all kinds of scams happening out there, but you don't want to just ignore it. If it's a review, if this is something where they're doing an annual review, you can't just ignore it and say, I thought it was a scam. Call back and say, is it really time for my review, and get that done.
If a child pays their fair share, can they still be claimed as a dependent on the parents' tax return?
Yeah. Now that is a really good question. That is a tax issue, so I'm not going to be able to answer it, but I have had that question. I've talked to several CPAs about that, and I'll be honest with you, I get different answers. But so I really don't want to delve into taxes because I'm not a tax professional, but there are certain things to claim your child as a dependent. Talk to your tax people, but you've got to be paying for that child. You can't have them paying everything and then you still claim them as a dependent. So depending on your specific situation, maybe your child is paying their fair share of the utilities and those bills, but you might be paying a whole lot of money out of pocket for them to attend a college program or to travel or to buy other things. So, it's not definitely one or the other, but that is a great question, and you should work with your CPA to see what they recommend.
Other than the stimulus check, we know that wasn't counted, but what if a family received any kind of other financial assistance from any other kind of agencies? Does that need to be reported to SSI?
Yeah, so if we're talking about a child under the age of 18, all of that needs to be reported because that child's eligibility is based on the household income. And so yes, you need to report that. And some of it may not count, but it always needs to be reported. If someone is over the age of 18, then income that's coming into the family home won't necessarily affect that child. So let me back up. So if my daughter, who's 26, is on SSI, I wouldn't have to report some money that I personally got because my income and assets have nothing to do with her. But if she got it, she's got to report it. So again, the household income, that has to do with children under 18. Once they're over 18, then they're looking at their own individual income and assets.
Thank you. So back to SSDI. If the parent who has the highest SSDI amount retires first, then the child's will not change. It stays with that higher amount.
Yes. So
Yes.
if dad retires first and then mom retires and it's lower amount, it's not going to change them over to mom's. Right. It's always going to be on the highest work record, highest earnings work record.
Okay.
Yeah.
Does it make any difference if the fair share is 200 or 700 to determine if someone gets the full amount or not?
The only thing that matters is that you show Social Security how you got that number. So one person's fair share may be significantly less than another's, and you just need the evidence to back it up. So if you have a really high mortgage, it's going to be a really high fair share versus a small mortgage or no mortgage or a small rent amount. And so no, it doesn't matter what that fair share number is as long as you can show what the amount is. So you need to report this. This again, you can't just do it. You need to report it to Social Security. And by the way, anytime you send a letter to Social Security, I would send it with a green card, proof of receipt, you know, the green card they sign, because you've got at least a 50-50 chance they're going to say they didn't get it. So you want evidence that they got your letter. And then once you report it, if my daughter's fair share is $500 a month, every single month I need to move that money from her account. And I do it this way. I transfer and I write fair share December 2020, and I transfer it from her account to my account. But I've got to have that evidence in there, because if I forget to do it one month, well, that's probably going to be an overpayment down the road when they look into it.
Great. Can you cash out savings bonds before the first of the month and put it in an ABLE account? If so, do we need to report this to Social Security? We told them about the savings bonds at the time we first applied for SSI.
So anytime you cash out a savings bond, you need to look at who owned it, okay? If the savings bond was in the name of the person with disabilities, if they would have had the right to cash it out, then it is their asset. And they need to report that as income, and they need to report. Now they can move it to an ABLE account, and that will help it not be a resource the next month, but it doesn't prevent it from being income in the month you cash it out. Does that make sense? So anytime you get income, you can move it to a trust, you can move it to an ABLE account if that's appropriate, but it still counts as income. Just putting it in, the only time, I know that's a little confusing, the only time it's not going to count as income if it is irrevocably assigned to that trust. And by the way, I'm thinking of child support again. You can't have child support irrevocably assigned to an ABLE account. It has to be a special needs trust. So if you've got a court order or something irrevocably assigning it, then it's not going to count. So if you have a retirement account that is paying directly into a special needs trust, it's not income because it's going straight to the trust. But you can't just take income and move it there and have it not count. Otherwise, everybody would do that.
Exactly. What if the family receives financial assistance from an organization, but that organization sent the check specifically to a provider? Do they need to report it even though the family never received any actual cash assistance?
So that you'd probably need to call me and tell me a little bit more of your situation. Again, if your child's on SSI and they're under age 18, then it might be that that's a benefit that counts. But if you're not getting the income, if it's just going to a provider, it might not. You'll have to call me and give me the specifics on that one.
Okay. We are a minute after 3. Do we have any more questions? Can you transfer child support from a first party special needs trust set up for child support to an ABLE account?
Yeah, great question. Yes, you can. Now, I will be honest with you, these ABLE accounts are pretty new, and the Social Security office is still kind of figuring out how to deal with them. But for sure, we've already got really clear regulations that we can transfer from a third-party special needs trust to an ABLE account. That's very clear. I also believe you can transfer from a first party trust to an able account, and we see it done a lot. The regulations are kind of still being discussed, so that could change, but right now, yes, you can. And
Excellent.
that's a great option, because once it's in the able account, you have more flexibility.
Excellent. Okay. Alison, thank you so much for an amazing presentation. So much great information, for taking time to answer questions. It was great. We would love to have you back in the future. I think I can get everybody to agree. We want her to come back and hear more knowledge from you. Watch for the handout to go up on our website in the next couple of days. Watch for an email that's going to have an evaluation link. We'd love to get your feedback. And thank you everybody for being here and working through our technical difficulties that we had at the beginning. And we hope to see you guys soon at an upcoming meeting. Thank you, everybody. Alison, thank you so much.
My pleasure. Thanks for having me. Have a great day,
Yes.
everyone.
Bye, you too.
Bye-bye.
Thank you.
Bye-bye.